That's people 77.
I've got you under my skin.
Americans are fascinated with the justice system, from watching shows like Cops and Law and Order, to following high-profile trials like O.J. Simpson, Casey Anthony, or even Michael Jackson's Doctor.
Yes.
Truthfully, we have a much closer and direct connection to the justice system than we might know.
Under my skin.
Of course, the way that we're most influenced by the judicial system has to do with that word we've been studying all year, policy. Remember that we influence the making of policy by electing folks that go to Congress and the President, who create the laws and then try to enact them. But then we have to think about how those laws are applied. If we commit a crime and the law says that we've broken on that law, then we are then subject to a justice system to determine our guilt and give us a punishment for that crime. We'll also take a look at how through judicial review the courts can actually interpret law, find it unconstitutional, and make it invalid. We shall begin at the beginning. The purpose of any court system is to be a third-party arbiter. You see, Party A and Party B are going to have beef, whether Party A is the government and Party B is a suspected criminal, or whether Party A is suing Party B because their dog bit their kid's leg. There has to be an independent, unbiased third person that can hear both sides of the story and determine whether one person is guilty or both or neither. And in order to determine someone's guilt, you can base that on a couple things. One is statutes, official laws that have been passed by a government. Or then there's common law as well, which is just assumed common knowledge. For example, maybe there's not actually a law written that says you can't steal someone's dog and shave them and then give them back the hairless dog. But that doesn't mean it's right. So the courts can still say, hey, you were in the wrong, you gotta somehow pay for what you did. And of course, those courts were speaking mostly of when they apply the law to circumstances. But what about interpreting the law and declaring it unconstitutional? Well, you remember we talked extensively about this thing called judicial review. And if we look back at what the Founding Fathers originally thought, they did not intend for the judicial branch, the Supreme Court, to be able to review laws and declare them unconstitutional. They said, no, you should only be applying the law to circumstances and finding people guilty, Party A, Party B, etc. But you remember that it was Marshall and Marbury versus Madison that said, hey, we have this power and there's nothing y'all can do about it. And from then on, the courts have been able to have a great deal of power in saying whether laws shall or shall not exist. Of course, James Madison would roll over in his grave. He believed that the judiciary only should serve to apply the law, and if it ever was able to be a check or a balance on the other branches of government, that there would be peril. Essentially, with these justices serving for life and really being beholden to nobody, for them to be able to have the ability to declare the laws unconstitutional, some would say that that is akin to legislating from the bench, or in other words, being able, with just a small group of people, to invalidate laws that the public has agreed to. Some people, like Madison, would think that's a little too much power for one group of guys to have. Guys and gals, excuse me. Now, what individuals are involved in the court system? First group is the litigants. These are the people that are involved in a lawsuit or in the crime, whether it's you accused of committing a crime or being on the receiving end, you're a victim, or if you're suing or have been sued, you're a litigant. Plaintiffs are the one that tend to have a complaint. They are suing Dunkin' Donuts because the coffee was too hot, right? Or they are the state, which is trying to prosecute somebody for allegedly committing a crime against the state. Speeding, driving under the influence. And a couple of things that we need to think about are the grounds on which somebody can sue. Go back to the coffee analogy. Let's say I do spill my hot coffee, but I don't burn myself. I just ruin my pants. Well, let's say that Dunkin' Donuts buys me a new pair of pants. I'm not going to sue because there's nothing that really has been wrong to me that hasn't been already resolved. I don't need to go to the hospital and get burn treatments. I don't have medical bills to be paid. And second, it must be a dispute which is justiciable, meaning that there has to be something the courts can actually do to help you. If you have a complaint about our country dropping missiles on another country, you can't go sue the government in federal court about that. That's something that is up to Congress and the President, and the courts don't really have any say in it, not particularly with your complaint at least. Other players in a court system are the attorneys. Of course, we have the prosecution, the folks that are going after something, whether it's the state and the district attorney that wish to prove someone committed a crime and prosecute them, or whether you have someone that is hired to sue another individual. We also have defendants, defense attorneys, which are helping out to either represent you if you've been sued, or if you've been accused of committing a crime, to try to prove that you're not guilty. And here we see our friend Johnny Cochran, famous from that O.J. Simpson trial, and he said that if a glove don't fit, you must acquit. And of course, O.J. Simpson was acquitted, and a lot of folks said, hey, come on now, we know that guy was guilty. He killed those two individuals. Speaking of that very question, after the fact, Johnny Cochran said, you know, the color of justice is not black, it's not white. The color of justice is green. Of course, he was responding to folks who say that white people have a better chance in the justice system than black people, and maybe they have a point. But his point is that it has more to do with how much money you have. He feels that he was able to get OJ off because he was a great attorney and OJ could afford him. Now, what if you were not O.J. Simpson and you were accused of the same crime and you didn't have money and you were assigned a rookie public defender? Maybe you wouldn't have the same chance that O.J. Simpson had. Some other players in the justice system are interest groups. Remember we talked about amicus curiae, the fact that those interest groups could, in addition to trying to lobby Congress to get laws passed, they could also send letters, friendly letters, to the court to say, please decide this way or that way. And they have groups such as the NAACP and the ACLU, which have been extremely effective in using this method. Of course, those organizations also have lawyers themselves that choose certain cases to represent a party where they can feel like they can actually make a difference in directing policy one way or the other in the country. Many have criticized the ACLU for choosing only to defend folks on the left or the liberal end of the spectrum, and to those folks I guess I would only point out that there are now organizations such as the Alliance Defense Fund that are choosing to represent people more conservative views, and hopefully that'll provide some balance. We need to be careful when we start talking about types of courts because of that thing called federalism. We have different layers. We have courts at the local level, the state level. We have state appeals courts, state supreme courts. But in a different jurisdiction, we then have federal courts, and those were set up by the Constitution. Congress was given the power to create a Supreme Court, and then as many inferior courts as they felt necessary they had to create. And that was done first by the Judiciary Act of 1789. I know you're remembering that that one is a little bit infamous for another reason, but one of the things it did that was upheld was created some lower courts. And Congress has also created legislative courts, such as tax court. These are courts that can't say, you know, a law is unconstitutional. They're just there to kind of apply the law when it comes to federal tax fraud and things like that. Let's look more specifically at those federal courts. You remember we've also studied this idea of original versus appellate jurisdiction. Original jurisdiction means that a case will be heard for the first time in a federal court, whereas if that case has been heard and one or more parties is not satisfied with the decision, they can appeal, meaning they can ask for a trial at a higher court, at an appellate court. And we know that the Supreme Court typically only hears cases on appeal. Very rarely do they hear cases for the first time because they are that highest court. You got to start lower and kind of work your way up. Here are some examples of those lower courts. They exist for particular reasons. You commit a federal crime like driving under the influence in Yosemite Park. Well, that's on federal land, so now you're going to have to go to federal court. Or if you want to file bankruptcy or you want to deal with immigration or something on the high seas, those are things that the states don't have any control over, so you'll be in district court at the federal level. The federal court system is divided up into districts. There are 12 of them. As you can see, we here in California are a part of the 9th District. And in fact, the 9th District Court is right here in Sacramento on I Street. The Court of Appeals for the 9th Circuit happens to be in San Francisco.